My name is Melanie Gray. On Friday, January 16th, 2026, at approximately 2:30 p.m., I stood before a judge in the Bergen County, New Jersey Chancery Division, seeking what should have never required litigation in the first place: the release of money that had been withheld from me for more than 4.5 years. For years, I was given explanation after explanation for why I had not been paid. I was told to wait. I was told to comply. I was told that once certain conditions were met, my money would be released. I did not understand the mechanics of escrow. I trusted the representations made to me. I believed that good faith would be met with good faith. It was not. When I was finally told that the escrow agent did not know what to do next, I sent a formal demand letter. That same day, instead of releasing the funds, the agency filed an interpleader asking the court to accept the money, decide who was entitled to it, and allow the agency to walk away without consequence. No trial, no discovery, no accountability. I wanted a trial. I wanted my voice heard. I wanted sunlight on a system that operates in silence. Surrogacy law is narrow. It concerns itself almost exclusively with pre-birth orders and little else. It does not address what happens when an agency withholds compensation for years. It does not address what happens when a woman is forced by judicial pressure to choose a date for induction against her will, not for medical necessity, but for the convenience of others. It does not address what happens when a surrogate is subjected to 24-hour, 7-day-a-week surveillance. It does not address emotional distress so severe that it manifests physically, including stress-induced preeclampsia. I lived all of this. I did not have a lawyer. I still do not. I sought representation and was repeatedly told some version of the same thing. What happened to you is terrible, but there is no law governing surrogacy, and therefore no clear path forward. I was left in a legal no man's land, a gray area where harm exists, but remedies do not. Despite this, I learned the law. I learned procedure. I learned how to file, how to respond, how to meet deadlines. I filed my answer to the interpleader within the 35-day time frame required by the court. The opposing couple, the same couple claiming I breached contract, did not respond. The court entered default against them. The escrow agency itself submitted paperwork confirming that default, meaning the funds could not be claimed by the couple and would ultimately be released to me. I provided the court with receipts showing exactly what was owed. For the first time in years, I believed I could breathe. Then everything collapsed. The default was vacated. The couple was permitted to answer late, with the agency's consent. And in that answer, they claimed they had already paid me in full. This directly contradicted their earlier position, which was that my funds were withheld due to an alleged breach. It also directly contradicted my documented evidence. This conflict alone should have warranted discovery. It should have warranted a trial. Instead, every claim I brought against the agency was dismissed. They waited 4.5 years until the statute of limitations expired, and then told the court that even if everything I alleged was true, my time had run out. They argued I had not produced enough evidence at a stage of proceedings where evidence is not yet required. When I filed a SIR reply on January 14th and did submit documentation, emails with conflicting explanations, transcripts of recorded calls, and statements from the other party indicating discovery was necessary. It did not matter. I was dismissed on all counts. So when my family, my friends, and my supporters ask what happened, the answer is simple. I was not heard. Not because I failed to act, not because I failed to comply, but because the system does not recognize harm when it exists outside narrowly written laws. And today matters. Today is Martin Luther King Jr. Day. That this hearing occurred on the Friday before such a day is not lost on me. It is a reminder that progress has never come from silence, patience, or waiting for permission. It has always come from people who refuse to accept that injustice was final simply because it was legal. I was not silent because I was defeated. I was silent because I was preparing, because I understood that I could not be heard in a courtroom. I would be heard in the public square. Today, I'm telling you that I am starting a grassroots movement to demand legislative protections for those who have fallen into this gray area, where there are no statutes, no safeguards, and no justice. We need justice in the gray. Justice does not end where the law stops. No law does not mean no harm. And silence will no longer be mistaken for consent. If you are where I am, or you have been where I have been, come find me. My name is Melanie Gray. And together, we're going to make the law catch up to the truth. Justice belongs in the gray.